Hello and welcome to the third episode of the Ahaki podcast on the theme Incarceration and Sexual and Reproductive Health and Rights in Africa. I still am Dr. Olga, and with me here is Abigail Machai, who is the Executive Director of the Zimbabwe Women Lawyers Association and was part of the legal team that represented Mildred Mapingure, a survivor whose decade-long legal battles exposed the devastating consequences of institutional failure in the aftermath of rape. So in this episode, we will be exploring the complex intersections of law, of reproductive justice, and criminalization in Africa. So this conversation will take us behind the courtroom doors into strategic thinking, into legal hurdles, and the broader implications of a case that, while successful, exposed several deeper structural inequalities in Africa. Thank you so much once again for being here with us, Abigail, and welcome again to the studio.
Thank you very much for having me.
So, Abigail, take us into the beginning. When and how did the Zimbabwe Women Lawyers Association first get involved in Mildred's case?
Thank you very much. So Mildred's case started off in 2006 is when the rape incident effectively occurred. But she was in a rural area that we were not working in, so she had no direct access to us as a legal aid provider. So she went to make a complaint against the conduct of the police and was referred to the Ministry of Justice, as it then was, trying to access legal aid services. In that particular space is where a referral was made to us as Zimbabwe Women Lawyers Association, and that's when we first interacted with Mildred.
Okay, thank you. You had mentioned that the case started in 2006. That's such a long time from now. My question is, when and how did you realize that this was just more than a legal battle, but also more of like a personal legal battle? When did you realize that?
So in interacting with her after the violation and understanding the facts of the case, that she had made every possible action or taken every possible action that an ordinary survivor could take in terms of trying to access termination as mandated by law, but had failed to do so, is when we realized that it was more than just the challenge that she had faced as an individual, but we actually had a problem that was systemic that needed to be addressed, how to get duty bearers accountable to deliver the service and implement the law.
Mm-hmm.
Yeah.
I think one of the most striking aspect of the judgments was the court's recognition of its failure or the state's failure to act in time. But the broader legal architecture of it that doesn't necessarily criminalize abortion, because I know that in Zimbabwe at that time, and I think even till now, abortion is not criminalized. Please correct me if I'm wrong. But from your litigation experience, how would you say that the laws that carry prison sentences, especially on sexual and reproductive health and rights, contribute to structural violence against women, not just in Zimbabwe, but even in Africa as a whole?
Yes, so I think the law is a big part in terms of whether one can access services or not. And starting off with the Zimbabwe position, you'll find that Zimbabwe has a very restrictive access to abortion law. So you can only access abortion in specified or limited circumstances, which include if it causes harm to the mother or fetal impairment, or in cases of rape, as was Mildred's case. So from a perspective of that narrow approach to access to abortion, it really becomes a big problem because within that context, even when the exceptions are given by law, you will then find cases like Mildred, where she just couldn't access the service. The law did give her a right, but she couldn't access in one of her interactions in that particular rural area with, for example, the nurses and doctors who were manning that hospital. They just said their Christian beliefs do not allow them to be able to support her. So you find that the context already plays a significant role in terms of whether one will access or not. And because of that particular perception, she didn't get the right information in terms of, okay, so where do you need to go to access the service? If in fact, they were making a runaround in the area and not necessarily getting the service. And in the meantime, the pregnancy is growing and she has no real access. Eventually, when she did get the information about this is the legal process you need to pursue, you will still find bureaucratic hurdles, even from point of when she knew what needed to happen. There was still stigma, hard opinions, lack of support in terms of how do you really support survivors to access these services. So by and large, we took the litigation on, but only got the order by court when she was 5 months pregnant. And by then it was rather too late in terms of being able to access the abortion services. So you find a failure right through the system. And it's not unique to Zimbabwe. When you look at just the restrictive laws around abortion and the direct impact on access to abortion for survivors or women in general, you'll find that it continues to be a barrier for women to actually enjoy their sexual and reproductive health rights.
Thank you so much, Abigail. You have said that it continues to be a barrier. I think my question before I asked the intended follow-up question that I had thought about, has there been any difference in the structural failures, especially when it comes to delays? Has there been any difference from the time that Mildred's case was instituted in court and now in 2025?
Mm-hmm. So one of the positive things out of that case, much as it took the longest time ever, was to instigate changes at national level. Changes that included, firstly, the law reform process itself, because the judgment did highlight that the law was a problem in the way that it was structured. It remained inaccessible for the majority. So there was an initiation of the law reform agenda. But besides the law reform, you found practical changes in terms of access, training curriculums for judicial officers, for health personnel, also changed in light of that particular decision and the experience that Mildred had gone through. So you find that it became a reference point for everyone to say, how do we avoid such pitfalls? Because you are actually found liable and guilty in terms of, as an institution, your failure to deliver. So you will find that there are changes. Certainly, at the moment, there has been a positive trajectory in terms of increasing access within the confines of the law. And the law reform process is still, pretty much early days, but at least there has been a draft that has been drafted that tries to simplify the process, that also tries to ensure that it does away with the hurdles, the bureaucratic hurdles that you might find from different actors. The downside, perhaps, is that it continues to ask for access through the court system. So you can't just directly get termination from the health system. And sometimes that becomes a barrier in and itself. But there has been positive change around trying to ensure that there's access. There's also been a lot of awareness. So when Mildred's case started, that was 2006, there was hardly talk about abortion in country or even talk around Maputo Protocol. It was early days. So you will find that the case did manage to break down those barriers and raise awareness and become a rallying point to say, this is what survivors go through. For them to be able to access termination, sometimes they actually don't. And these are the problems that we need to pay attention to. Yeah.
Thank you so much. So this case took almost a decade or more than a decade. What were the most difficult moments for you and your team, either legally or personally, as you navigated this prolonged process?
So I think the case itself, the length of time was a very long time. So you can imagine interacting with a survivor of violence from 2006 And up until 2014, at every turn in court, you were saying we were not successful. The court said there's nothing that could be done. Go home, put the child up for adoption. Those were the options that were being given by the government at the time in the case. And yet, as the legal counsel, you're interacting with a real individual who is saying, I've been shunned by the entire society. I've lost my marriage. I've been shunned by the communities. I have this pregnancy and now I have this child and I can't get any support from the actors that are supposed to provide support. So it was very disheartening, and it took a lot in terms of remaining resilient and remaining on the ball. And I think a lot of the conversations were around how do we sustain this litigation that we want to bring broad change, but at a very personal level. Mildred is not getting any joy. She's gotten nothing out of the process. When we started in the magistrate's court, the case was just about trying to access the termination of pregnancy order. And that came at 6 months when it was long overdue. And you're interacting with her and saying, well, we've got the order, but nothing can be done now because it's well out of time. And then, you take the next step. No, but we need to hold these actors accountable because it can't be in this way. And we started on the High Court litigation, saying there is a problem in the system, a structural problem for that matter, because survivors like Mildred cannot access the services. And in the process, she has real issues. The baby wants food, she needs accommodation, she needs postnatal care, just the day-to-day subsistence issues. And it was always a difficult balance between you trying to push strategic litigation versus the real needs that she had. We had support in terms of the litigation. Projects come to an end. Most projects are 3-year time bound. You're doing litigation almost 10 years.
Yeah.
And you just cannot sustain the momentum. So there were real pressure points. But I think for me personally, the big out of it was her personal resilience. Notwithstanding all the disappointments, all the challenges that were there, she kept saying, I couldn't terminate, but what I can do is to at least try and change the system for many other survivors of rape so that they don't go through what I have gone through. And that became the silver lining, and it became what sustained the litigation. I think the joy in terms of the case only literally came at the tail end. That's probably 2012, when the Supreme Court then said, okay, yes, there is a problem here, and we have to hold these actors accountable. So it was highs and lows, but I think at the end, just her resilience and her capacity to continue, notwithstanding the difficulties, became the momentum we need to push the litigation through.
I know you've spoken about the silver lining and the joy at the end, but do you think that there is a knowledge gap? Because when you spoke about ostracization from families, from her ex-husband abandoning her, and several others just treating her like she was the one who actually committed the offense, meanwhile she was the survivor in all of this. Do you think that there is a knowledge gap on sexual and reproductive health and rights, or even sexual and reproductive health services in Zimbabwe and even in Africa?
Certainly, the knowledge gap is a big thing. And even more so when you talk about sexual and reproductive health rights, it becomes even a bigger challenge. You will find that these are not issues that were spoken about. So even if the law was there in Zimbabwe, it's not like there was common understanding to say, these are the 5 steps you need to take, this is where you need to go. There wasn't literature around in terms of litigation, there wasn't prior precedent. So this became the first case really to kind of, open up that conversation. And I think it's one of the things we celebrate in terms of the impact of the case, because pursuant to the Supreme Court finding, you found that awareness raising became a big issue. So whether it was led by government ministries, they were now raising awareness that, the law says you can access in these circumstances, and this is what you need to do. The conversation started opening up. Even at community level, people were talking about how can you not access when the law does give access. So it became an opening for the broader conversation around issues that are sensitive for many communities, such as abortion. That became the opening that was required for the conversations to start going. There was a whole focus around the issue now to say, let's look at how many people have actually accessed beyond Mildred. Are there people who have actually accessed, or it's just a law that's not working at all? So awareness continues to be a big issue that we continue to all need to contribute in terms of just breaking down the information barrier.
Okay, thank you so much. I think from the Mildred case, and like you said, how the case opened up awareness and opened up so many positives in Zimbabwe. I know that many people now cite the Mildred case as a landmark case when we're talking about sexual and reproductive health and right, or even reproductive justice broadly in the continent. From your perspective, what legal precedent would you say the case established or failed to realize? Mm-hmm. Was there any failures? Was there anything you think that the court could have even done better, even though this was a landmark ruling?
Yes. So I'll start off with perhaps the successes and come to the areas where the court failed to take the opportunity. I think broadly, in terms of just holding those duty bearers accountable at a national level, was a positive stride, which gave the message out there that you can actually get duty bearers to be accountable for delivery of different services. And I think at a regional level, you'll also find that when the case started off, Maputo was not a conversation that was in the legal corridors or pretty much in communities. Yet, for a country like Zimbabwe, they had signed on to the Maputo Protocol. So you will find that one of the things that we did in the case was to also cite the Maputo Protocol and the duties of the Zimbabwean government in terms of delivering the rights that are articulated in the Maputo Protocol. And it was a first because, by and large, reference to Maputo was not a big thing, even within the legal corridors in and itself. Mm-hmm. So those are some of the positive attributes that we started to see, because then the court, even in coming up in its decision, also made reference to the Maputo Protocol, which was a positive. I think on the downside, the court failed at a direct personal level. They failed ultimately to give Mildred damages for and maintenance for her child. So the case was two-pronged. While seeking damages for the failure of the different duty bearers, it was then also saying because of those failures, there was a duty to maintain this child that was there. And the court didn't want to touch on the duty of maintenance. In fact, they said the father, whoever he is, he's out there, and he, as an individual, has a direct duty to maintain this child born under these circumstances. But beyond that, just the opening up of conversations around abortion and the structural challenges that existed, I think the court could really have moved the needle a little bit more there in terms of how do you address structural barriers beyond just, issuing a portion of damages in this particular case. So I think they could have been more, but at the end of the day, when you put in the context, you tend then to see that the progressive steps are far more important at times than wanting the whole cake, because context will tell you that this was even a big push that was done at the time. Yeah, so that's what I would say in terms of what the outcome of the case meant and what it has done. Yeah.
So at the heart of this case, I think this case revealed what happens when survivors are entangled in a system that criminalizes sexual and reproductive health care. What institutional failures would you say, or maybe I should better put it like, how did the institutional failures of the state affect her right to safe and legal abortion? And maybe how does it continue to affect the right to safe and legal abortion for Zimbabweans?
Okay.
Yes.
So the institutional failures had a direct bearing on whether Mildred, in this particular case, could access abortion services. So when you look at the structure of the law, for you to access an abortion service in the circumstances of unlawful sexual intercourse and you fall pregnant, you have to navigate the criminal justice system. And your navigation of that criminal justice system starts off with the police, who then present the case before the prosecution. The prosecution then take you and present you before the magistrate, which is your first port of entry in the justice system for Zimbabwe. And then based on the decision made by the magistrate, will they grant you a termination order that you then take to the hospital to actually access the abortion. So that's by sequence how this should work out. And so effectively, when you look at Mildred's case, the police that needed to make the report are a specialized unit. In a small rural town like Chegutu, where she was found, this particular officer, the specialized officer, was not available for almost the week. So it meant that there was nothing that was presented before the courts, because the issue was we have to wait for this particular victim-friendly officer to then come, take the recording, then present you before the prosecutor. So because of that, the 72 hours that are required for a rape survivor to access post-exposure prophylaxis, which includes emergency contraceptive, lapsed because there was nothing that could happen at that local police station in a rural area in Zimbabwe. Then that failure eventually led to a delay in the matter being presented before the prosecution. It being presented after the failure to get post-exposure prophylaxis meant the most immediate other remedy was a termination order. Before the prosecution's interpretation of the law was such that you need to wait for us to pursue the armed robbery case, because she was raped during a robbery. Let's pursue the robbery case and then pursue a rape case. Then once we have those two cases, can we then come back to the issue of termination? So it was a clear wrong interpretation of the law. And the prosecution in this small town had consulted the magistrate in that area. So this was where liability of the judicial officers was found or established, because they gave a wrong advice. So she waited based on the advice that she had been given, that let's first pursue these other crimes and then come back to the issue of termination a little later. Eventually, when she managed to access legal aid or legal counsel, is when we came into the picture to then say that's not the correct interpretation. We must get the order. But then the order in itself only then came out late. So those delays at the different stations that were compounded by the fact that she was staying in a rural area. So sometimes when we talk about the barriers, we also didn't pay attention to the dynamics within the context. Access from a provincial center, from an urban area means very different things for women and girls living in rural areas, where the navigation is not as straightforward. So these delays are effectively what contributed to Mildred failing to access a right that she had that was protected by law.
So finally, Abigail, for lawyers and civil society organizations who are supporting women who have been criminalized, who are currently incarcerated, or just at being at risk of being incarcerated, what lessons can they take from your legal strategy in this case?
Okay. I think the lessons that I would highlight would be three main lessons. The first lesson really is about centering the survivor in the litigation strategy itself. Because if you don't center the survivor, when you meet these challenges, I spoke about the delays in just the justice system itself, what that meant to the individual. If you don't center the survivor, then your response is going to be very irrelevant, perhaps, to the context of the survivor. So it's important to center the survivor, to also, within centering the survivor, ensure that you do no harm. She's already been harmed. How do you protect in cases that are as stigmatized as sexual and reproductive health rights? How do you ensure you protect the individual? In that, I remember at a time when we were doing the case, she was not doing any media engagements, even if we had a media strategy, because we needed to protect her. As the case started off, it was a case of wanting to terminate. She then had to then start to learn to love this child and start to live and be a mother for this child. So whilst this litigation was going on for a decade, her child was growing up and there was a need to strike a balance. So it also meant ensuring that you protect the child and the mother, and ensuring that you have many other services around the survivor, whether it's the psychosocial support, shelter services that might be in need, just different services around the survivor. So I'd say centering the survivor in the strategy becomes critical, particularly when you're talking about reproductive justice as a thematic area. It becomes very key to center the survivor and ensure that you're protecting the survivor. The other issue that I wish to highlight is also in terms of the advocacy strategy as a whole. So litigation becomes one component that needs to be anchored in broader strategy. And this strategy really ensures that you're pushing different aspects, whether it's the law reform, whether it's the awareness that we're talking about, whether it is the capacitation of the different duty bearers, but multi-pronged in and itself, so that you have broader change. Connecting the litigation with what is happening at community level becomes key, because you don't want changes that are happening in isolation to what is there at community level. And the last that I would mention is really around alliance building and partnership as a key strategy, so that the litigation becomes a collective issue, and working with different partners across different areas for the litigation itself, working with experts, working with community-based organizations, different people running with different things, supporting the litigation itself. Those, I think, would be the key lessons that I would draw from the litigation in the Mildred's case.
Thank you so much, Abigail, for your insights and for your role in this case that has become a reference point in the struggle for advancing reproductive justice in the continent. I think, as we've heard today from Abigail, we now know that when an institution fails, it actively harms. And just as Mildred's case demonstrates to us, when justice is delayed, it is often denied. But thankfully, in this case, we didn't see justice being denied, but we cannot separate ourselves from the structural harm that institutions cause, or when they fail to act at the time that they're supposed to act. So thank you so much for listening. And thank you once again, Abigail, for being here with us. Kindly share this podcast with your networks. And till next time, see you. Thank you.